and I'm glad to now introduce Tom Gibson from Chambers, who's built up, I think it's fair to say, an enviable practice in clinical negligence and personal injury work since he abandoned the rarefied world of slaughter of May and transferred to the coalface. He acts for both claimants and defendants, very well recognised in the directories. He's one of our established stars of the junior bar and a joy to work alongside. So over to you, Tom.
Thank you very much, Elliot. Let me start by screen sharing. Elliot, you should now be able to see the title slide.
I can indeed.
Fantastic, thank you. Well, thank you, Elliot, and thank you to everybody for joining. This talk is Cauda Claim Catastrophes, Committals for Contempt of Court. Before I dive into the detail, I should say a few words about how this talk came about in the first place. I think when I was asked to speak at this event, sort of something quantum related, maybe a quantum legal update was the brief given to me. Perhaps unsurprisingly, if you look for reported decisions, recent decisions on quantum trials featuring Cauda Equina, there aren't any. There is presumably a lot of good common sense, pragmatic cooperation between claimants and defendants. Most cases settle sensibly at JSMs, maybe at mediations, with them being popular in the last couple of years. So there aren't many big quantum trials for me to tell you about. What we do have, however, are two cases from the last 2 years, both Cauda Equina claims, that ended up with the rather extreme scenario of the claimant facing a prison sentence for contempt of court. Is this all a bit extreme? Well, before writing this talk, I did speak to Elliot and say, is this something that we could or should talk about? Is it too extreme? Is it perhaps too disastrous from the claimant perspective? Though we agreed that this is worth looking at because we've got these two reported cases. They've happened. They are newsworthy. Even if it's something that you may never have come across in your practice and may hope that you never come across, certainly from the claimant side. These cases are interesting, so let's have a look at them. So there in the introduction, with apologies to Oscar Wilde for me butchering the importance of being earnest, I think he would have said to lose one committal hearing may be regarded as a misfortune, to lose both looks like carelessness. So the two cases we're going to look at, first from February 2021, last year, a judgment of Mr. Justice Griffiths. Secondly, we've got North Bristol and White, just from a month ago, from Mr. Justice Ritchie. Before going any further, when you do these talks, you're never quite sure who's listening. We've had over 100 joining us live online today, which is fantastic. I think Victoria will also be putting them as viewable on demand on our website's very own Outer Temple player. So people will be watching later as well as today. If this was your case, I'll apologize if I misrepresent it. You can tell me afterwards how accurate or inaccurate my summary is. Though in seriousness, these are complicated, long-running cases that had difficult, torturous outcomes by their nature. Obviously, I've condensed them down and summarized them so we can cover the key points swiftly today. So let's start our case study with Calderdale and Huddersfield and Metcalf. We're going on a tour to Yorkshire. The photo in the top right-hand corner is the Royal Calderdale Hospital in Halifax. And this is where Miss Metcalf, when she was 25 years old, found herself attending A&E 3 times in quick succession. Saturday, 30th of June, 2 days later again on the Monday, 2 days again on the Wednesday. She returned to A&E for the 4th time the next day, Thursday, the 5th of July. This time she had the MRI scan, I think linking to what John Leach was talking about at the start of today about the availability of MRI scanning in district general hospitals. Following the MRI scan, we know she was operated on. She brought a clinical negligence claim as a result of the delay in diagnosing the Cauda Equina Syndrome. The judgment doesn't give us more details than the quote I've put there. The judge Mr. Justice Griffiths points out in that, of course, the trust's not responsible for the original condition, but it was alleged and conceded that Miss Metcalf had become worse because of the negligent failure to act and diagnose. And the liability admission made here, pre-action, was the 4th of July. So just one day, 4th of July attendance to 5th of July attendance. But we had the admission pre-action, the formal apology, and an early interim payment of £75,000 to Ms Metcalf. So far, so straightforward. On we go with a quantum case. Things started to, well, with hindsight, go wrong once Ms Metcalf was speaking to her experts. We've got examples in the judgment, and here's one of them I've quoted in full here. Denise Winks, care OT expert, was told that her ability to take part in leisure and social events were limited due to mobility difficulties and levels of pain. There was no reference, you can see where this is going, there was no reference to her trips to Fuerteventura, France, Spain, Tenerife or Thailand since she was last interviewed by Miss Winks 7 months earlier, although she did state that her boyfriend visited her at her parents' house and she went on holiday with her family. Miss Metcalf also told Miss Winks that her indoor and outdoor mobility had deteriorated to the extent that she needed to use 2 sticks for all walking, and her walking distance was limited to approximately 30 metres. She reported she hired a mobility scooter at the supermarket. Among other complaints, she could not sit herself up in bed on her worst days. She had to have assistance from her mother, and her mother also assisted with washing and dressing if her pain levels were worse. And moving on to the following year, 2018, her condition was presented as even worse, unable to drive at all, only able to stand supported without walking sticks for a few seconds. Surveillance evidence then appeared in Miss Metcalf's case. We're not given, again, huge details in this judgment, though we are told that there was covert surveillance collected in 2017 around expert witness appointments, as we'll see in a moment, with further material in July 2018. And we've also got the internet searches showing her travelling frequently and easily in the UK and overseas and walking without sticks or other assistance. And then we have the rather ominous sentence, Mr. Justice Griffiths saying, a substantial amount of this footage has been played to me in court. One example of the footage, which I quite like, I've put in full here. I told you this was a tour of Yorkshire. In case you don't recognise it, this is the Grand Hotel Scarborough. There it is from the beach. And this is where Miss Metcalf went on one of her days when she was being examined by expert witnesses. It was the Professor McVie, the surgical expert in Scarborough. And we're told that before the appointment, she walked to the Grand Hotel, stood in reception area for over half an hour and aided. She was then driven to Professor McVie for the consultation, where she transferred from the car into a wheelchair brought with her, which she was not seen using in any of the surveillance videos of her in Stockport and Scarborough earlier in the day. She left his consultation rooms in the wheelchair, was driven back to Scarborough Promenade, where she walked unaided to a restaurant. On leaving the restaurant, she walked along the promenade without using a wheelchair or sticks for about 20 minutes. She returned to her hotel and climbed the steps to go in without using the handrail. The use of the wheelchair and sticks when she was in or near the premises of experts she was misleading about the extent of her disability was not only unnecessary, it was obviously part of a plan. And I've been shown it adopted on video on more than one occasion. Well, what happened next? As usual, the defendant, careful timing. In January 2019, Ms Metcalf serves her updated schedule of loss, claiming around £5.7 million. 4 days later, the bombshell lands, the surveillance evidence is served. Evidence showing, the defendant says that her claims were based on lies and her presentation of herself was a fabrication. And following that, a couple of months later in April, we had the amending defence explicitly alleging fundamental dishonesty. What happens next? Was there going to be acceptance or admissions? Well, not at this stage. Ms. Metcalf at this point had a reply signed by her personally denying fundamental dishonesty, reaffirming reliance upon the full witness statements, expert evidence, and other evidence served on her behalf. The title of this slide comes from Mr. Justice Griffiths' words himself. Her position was, however, hopeless. The trial was listed for September, so we're pretty close to trial now in spring 2019. We had the failed JSM on the 10th of June 2019. And then 8 days later, she agrees 3 months before trial, 4 months after the disclosure of the evidence against her, and nearly 4 years after she had begun her dishonest contempt of court in pursuit of a fraudulent claim, that her claims should be dismissed because of fundamental dishonesty. And she agreed to repay the interim payment of £75,000, which she did do in instalments over the next year or two. This tour of Yorkshire now moves on to, I think, the final place. Here we are at Leeds Combined Court Centre for the committal proceedings. Following the end of the civil claim in June 2019, the trust issues and serves the claim form seeking permission for committal proceedings in March 2020. This time we do have early admissions. Ms. Metcalf's solicitors admitted contempt on her behalf almost immediately. Instead of the permission stage, we had consent to bring committal proceedings. And that led us to the final hearing before Mr. Justice Griffiths on 11th of February last year, 2021. There he is, Mr. Justice Griffiths, looking suitably stern in his full-bottomed wig. And here, as he summarises the case, he says Ms. Metcalf's dishonesty, had it not been discovered, would have extracted millions of pounds from the trust and through them from the funding of the NHS. An attempt was being made on a vast scale over a period of years between October 2015 to January 2019, systematically and shamelessly to pervert the course of civil justice with a view to financial gain. And he quantifies the damage there and says, well, it's agreed that the genuine, legitimately recoverable damages were roughly in the region of £350,000. Yet her claims, based upon the extreme disability which she falsely alleged, were in excess of 5.5 million. And we've got the total that Ms. Metcalf lied to a total of 13 different experts on 19 different occasions and signed various statements of truth to matters which were not true. She also accepted, in addition to the potential loss of 5 million to the NHS, she accepted that both solicitors and counsel had lost a lot of money as they'd worked on her behalf to pursue a complex claim that had come to nothing, as well as involving family members, not being separately pursued this time, but the sort of dark hint is there in paragraph 15. The sentencing, I'll go over this briefly, as this is exploring Cauda Equina case studies, not a sort of criminal procedure talk, but the maximum's 2 years for contempt of court. Here we've got the number of contempts, the range of deliberate, not reckless conduct, the manufacturing of false evidence, systematically deceiving expert witnesses on both sides, a long period of time, millions of pounds at stake. That put Ms. Metcalf's conduct in the upper bracket of the contempt scale. So the starting point for sentencing is 18 months. Maximum 2 years, starting point 18 months for Ms. Metcalf. To that, though, we consider the mitigating features. One point being Ms. Metcalf did have a genuine claim that she's lost compensation, and she had paid back that £75,000 interim payment. She was in poor health. Though Mr. Justice Griffiths comments perhaps caustically, it's difficult to determine the extent of how poor the claimant's health is, as her credibility has been destroyed. We've got no previous convictions. We've got the early admissions of the consent to bring the contempt proceedings. And she was also a mother to a young child, now 2 years old. That mitigation reduced the 18 months to 9 months, and that was taken down further to 6 months for the full admissions made at an early stage in the contempt proceedings. Would there be a suspended sentence? Could Miss Metcalf, bluntly, could she stay out of jail? No. Appropriate punishment, faking evidence in support of a claim inflated by some £5 million can only be achieved by immediate custody. So 6 months immediate, that's the sentence, no suspended sentence here, but that is an automatic release after 3 months of the 6-month sentence. That was Metcalf. Now let's look at North Bristol and White. This time we've got a trip to the West Country. A little bit more colour and more detail in the judgment this time. Miss White grew up in the Barnstaple area. Her parents separated age 14. She had poor GCSE results. We're told she got into trouble with the police. But as she moved into her later teens, there was a much more positive picture. We're told that by age 18, she was working as a care assistant and or trainee nurse for BUPA in a nursing home in Bristol. She had a partner working as well. The two of them were building a life together. Her aim was to go into nursing or midwifery, and sort of her life was back on track. She's starting to build a career age 18. Interestingly, Miss White's mother had Cauda Equina Syndrome, needing self-catheterization and anal irrigation. Miss White herself, a past history of IBS is mentioned. Though spring-summer 2011, we've got a sort of progressive history of onset of back pain. In April, perhaps a fairly standard-looking strain, back pain for 2 weeks, helping an old lady out of a chair at work. Moving on into May, we've got suffering some urinary leakage since the February. Lower back pain thought to be related to the urinary tract infection in May. Moving on into the summer, we've got in June, urinary leakage, lower back pain, by that stage going into her left leg. 4 days later to the GP, GP being told explicitly that her mother had suffered a slip disc resulting in Cauda Equina Syndrome, lower back pain going into both left and right legs. July, fecal incontinence while on holiday in Tunisia. And then August, GP noting increased lower back pain going into her left leg, no perineal numbness. And then at the end of August, there was the referral to French Hospital in Bristol for an MRI scan, perineal area normal at that time. So we moved to Bristol. I should have said by this point, Miss White's working in the Bristol area. She's moved there from Barnstaple. So welcome to French Hospital in Bristol. 18th of September 2011, she attends A&E. As the slide says, we've got leg pain, lower back pain, pain in both legs running into her feet, but no examination for Cauda Equina Syndrome. Discharged because she's already waiting for an MRI scan as an outpatient, no neurosurgical review. We'll see in a moment, this is the genesis of the clinical negligence claim, because where are we? 3 weeks later, we've got representing to hospital, lower back pain, increasing leg symptoms. This time the MRI scan disclosed a disc prolapse. And then 3 days later, we've got surgical decompression, L4, L5 for a central disc prolapse. So the claimant's claim, she claimed that Cauda Equina Syndrome had led to 3 main areas of symptoms, bladder symptoms, bowel symptoms, and her left ankle, which she asserted was weak. And we've also got an allegation she could no longer enjoy any feeling during sex, as well as the bladder and bowel issues. September 2014, the claim forms issued. Allegations about 18th of September that first attendance to A&E. Liability was denied, as was causation. So we go through liability proceedings until 2 years later, we've got a liability settlement. The judgment mentions an approval hearing by His Honour Judge Cotter, pictured there as he then was, now Mr. Justice Cotter. It doesn't say why there's an approval hearing, given that Miss White was not a child nor a protected party, presumably. But anyway, that's what we have. a liability, perhaps breach of duty settlement on a 50-50 basis, covering causation of Cauda Equina Syndrome, but did not cover causation in relation to the extent of the symptoms claimed by Miss White arising from Cauda Equina Syndrome. Those are still open for the quantum trial. We've also got liability cost interim payment of £82,000 and interim payments totaling £45,000 paid to Miss White herself, paid during summer 2017 through into spring, autumn 2018. Meanwhile, okay, that's good that legal claim liability is compromised onto the quantum claim. What happened in the real world since the September, October 2011 surgery was a bit more complicated. At the end of 2011, Miss White had 3 months off work after surgery, and there's a dispute in that the medical notes say that her bladder and bowel were normal, although Miss White said no, she didn't accept that. January 2012, so 3 months after her first spinal operation, she's back at work. An MRI scan 2 months later is showing multi-level disc disease with prolapse at L2, L3, but no compression. And then by August 2012, we've got urodynamic tests because she wasn't voiding bladder properly. By September, she was advised on how to self-catheterize, and Miss White saying she's been self-catheterizing 5 to 6 times a day continually since September 2012. The judge, and now we're Mr. Justice Ritchie at the committal hearing, saying that Miss White had given up work by September 2012 after reducing hours in July. However, it stands as a fact that she had worked as a care assistant full-time from January to July 2012. She'd also been claiming benefits, perhaps unsurprisingly. By this point, she stopped work. So since 2012, she claimed income support, disability living allowance, care and mobility, housing benefits, and was provided with a mobility vehicle. Moving on, her son was born the following year. We have a second spinal operation in 2014, L5 nerve root decompression. And again, a conflict between Miss White and the medical records, her saying this made no difference to her bladder and bowel symptoms, the notes suggesting that the bladder and bowel sensation was reduced substantially after this second operation in February 2014. Moving on, another MRI scan a year later in 2015 showing L4, L5 disc problems again. By late 2017, we've got increasing right leg pain, and then the third spinal operation in February 2018, the revision discectomy at L4, L5, the same level that was first operated on in October 2011 at the start of this claim. And that was successful in relieving right leg pain with Miss White being discharged from physiotherapy. So where does this leave us? We've had a complicated factual background, 3 spinal operations by now, the third one a revision. We've had Miss White carry on work for 6 months, but then part-time stop work. Following the liability settlement, we've got the quantum claim. A shorter quotes from a witness statement in 2016 saying she's still in a lot of pain, her left leg felt weak. We've got more details by the end of 2017. We've got, first of all, a disagreement with the notes saying that she hadn't had normal bowel and bladder function, that she'd been self-catheterizing since September 2012. Focusing on mobility, as I think you might guess, this is where the evidence is going to come later from the defendant. She said in her witness statement she used one elbow crutch while walking outside. Lifting one of her son's toys or sitting for 30 minutes led to a significant increase in pain. Her partner did all of the cooking, washing clothes, cleaning and shopping. And while she could wash and dress herself, she did sometimes need help with socks and shoes. Did Miss White tell her own experts? Again, on mobility, she told Mr. Todd, the neurosurgeon, weakness of the left foot and ankle with regular falls, cruising the furniture at home for support, outside walking with an elbow crutch, a maximum walking capability of 20 steps. Mr. Nees Winks interestingly, the same care OT expert as we saw in Metcalf. Miss White, when she was examined by Miss Winks, well, there was extreme pain on walking, weight bearing, not much mobility. A second assessment after her third discectomy operation, we've got short distances again with extreme pain. And we've got Dr. Munglani, pain medicine, again examining Miss White before and after this third operation. Dr. Munglani being told that she can walk with a crutch for roughly 20 steps and has to stop due to pain in the lower back and leg, and that her walking was completely wonky. There was also an examination by the defendant's neurosurgeon, Mr. Jelinek, and looking at this case afterwards, I wonder if this was a large part of the large factor that led to surveillance evidence and the contempt proceedings that we ultimately end up at. Mr. Jelinek points to clear organic inconsistencies in the presentation of Miss White's symptoms. Perhaps there was a little bit of expert detective work as well when we've got this sentence that Mr. Jelinek observed Miss White walking the hospital towards and away from the examination. Yet when he formally assessed the strength of her left ankle, the power was 0 out of 5, no movement. And Mr. Jelinek saying, obviously rightly, well, Mr. Todd's found 5 out of 5 power and motor power in the left ankle. I found 0 out of 5. Both of us can't be right. There's no organic explanation for this apparent profound motor deficit. Following those expert examinations in summer 2018, we've got the schedule. This time it's between 4.2 and 4.3 million pounds gross of the 50% liability settlement. We've got a lifetime loss of earnings claim. We've got substantial property adaptations due to substantial mobility symptoms. We've got medical treatment costs, and then the care and case management claim claimed at over £2 million. In that autumn, we've got the surveillance evidence videoing Miss White during October. And as the judge says, that showed Miss White visiting Tesco's, Sainsbury's, and a variety store called B&M. She drove to and from these stores, getting in and out of her car freely and easily. She walked around the stores without any apparent limp, slowness, or disability. She bent down and sorted through clothes in the back of the car. She bent down and looked at calendars. She walked with a dog on a lead. It was apparent to any objective observer that Miss White's complaints to various medical experts and other experts were false and misleading. After the surveillance evidence, in December 2018, the videos were disclosed, and we've got, interestingly, from the defendant trust, an offer, I suppose, drop hands offer, withdraw the claim, no costs order. That wasn't taken up. In January, February, we've got Miss White, perhaps similar to Miss Metcalf, at first saying, no, I stand by all my evidence. She serves a witness statement saying that she hasn't been dishonest despite the videos. However, things are unraveling at the same time. We've got Miss White's own experts commenting on the videos and all saying, well, this paints her in a completely different light to what I saw. Mr. Todd went so far as to say that it looked as though she'd been deliberately misleading. Around that same time, perhaps as the expert comments came in, we've got the claimant this time offering to have the claim dismissed with no costs on either side. By now, the defendant doesn't accept that offer. We've got the defendant's counter schedule pleading fundamental dishonesty, saying that the honest case is worth £80,000 to £150,000 before the 50% deduction. At the end of February 2019, Miss White's solicitors are off record. And then the civil claim ends a couple of months later. His Honour Judge Gore QC strikes out the claim for various breaches of court orders for Miss White. Solicitors off record by now. Though I've included this slide to show that apparently at this strikeout hearing, Miss White described as being clearly contrite and didn't oppose the striking out, realising dishonesty had been identified. And then again in paragraph 41, we've got Mr. Justice Ritchie highlighting over £300,000 by now has been paid out in damages, costs, interim payments, plus the defendant's own legal costs. So that's the end of the civil claim. Now we're on to the contempt proceedings. Delays due to COVID, though we've got permission granted in 2021 after the claim being issued in 2020. This time, unlike Metcalf, we don't have the full sort of frank admissions of the contempts of court. We've got correspondence, we've got partial admissions, but no admissions at this stage to dishonesty about Miss White's pain levels or about her intention and her knowledge when she was seeing the experts and serving her statements. As a result, we've got a 3 to 4 day committal hearing listed for last month. You can imagine the amount of work the defendants had to do to prepare for this. They had witness statements from 10 of the expert witnesses that Miss White had seen. 7 of these had required for cross-examination. And indeed, we're told that 4 experts turned up to court on the first day, ready for their turn in the witness box. However, perhaps unsurprisingly, the very night before the hearing, Miss White agrees a clarified set of admissions, which is described as pretty much what the trust had asked for. So that included false statements to the Mr. Todd, Ms. Winks, Dr. Manglani that we looked at earlier. We've got Mr. Justice Ritchie's findings of fact here, but based on the late admissions, that between May 2018 and January 19, Miss White dishonestly and intentionally made false statements to 4 experts. And this increased the value by at least £1,000 gross of what she was claiming, probably substantially more than that. Mr. Justice Ritchie also comments that this witness statement in January 2019, that was continuing to propagate lies about her state of mobility as set out in admissions with the same purpose, to increase the damages. And that was particularly important because this was after the surveillance videos had been disclosed. And that was just compounding the dishonesty, and that behaviour showed a lack of insight towards the court and the taxpayer who funds the trust, and towards justice itself. We're very nearly at the end of this talk, but before we do finish, there is just time, I think, Elliot, for a bit of audience participation. Don't worry, you don't have to come off mute, you don't have to say anything, but we do have a poll. So Victoria, if we could start the poll, fantastic. I'm being a little bit unfair to you. Mr. Justice Ritchie's judgment has a very useful appendix with 11 contempt of court cases in clinical negligence, personal injury claims. He discusses the law in great detail. He discusses mitigation. But I think the key points, you've having listened keenly to Metcalf and seen how that claimant was sentenced last year. We've now got Miss White's case. Just to give you a bit of a reminder, we've got 0 to 2 years as the maximum. We've got, it's accepted that this is going to be a custodial sentence. A fine, it's too serious for a fine. We've got some mitigation. It's and we have a 9-year-old son, the lost genuine clinical negligence claim. We've got physical challenges from her own poor health, as well as from any negligence. There's a psychiatric report that's not really elaborated on, and we've got some delay with these committal proceedings hanging over Miss White's head for nearly 3 years from, well, yes, 3 years from Judge Gore striking out her civil claim until this committal hearing last month. Hopefully the votes should be coming in. You've got another few seconds. I've given you 4 options there. 12 months immediate, 9 months immediate, 6 months immediate, or 6 months suspended. Those are your choices. You'll have to shoot from the hip, and we'll see in a moment. Excellent, interesting spread of results. We've got, I can see those. Thank you. Elliot, can you see those? I think everyone can see the results.
Yes, I can see those.
Fantastic. So we've got 40% going for the 6 months immediate. We've got 25% who are the good draw at the sentencing hearing, if you're representing the defendant, Miss White, who've let her escape prison with a suspended sentence. We've got another quarter saying 9 months immediate, and we've got perhaps the harsh 11% saying this is a full year, 12 months immediate. That's interesting. Moving on. The result, well, the starting point was 12 months imprisonment, reduced to 6 months as a result of mitigation. No further discount here as there was in Metcalf for the admissions, as they were so late the night before the hearing, but it's not appropriate to suspend, weighing up the factors and the case law around that. So the result, 6 months in immediate imprisonment with the standard entitlement to release after serving half. Which brings me on to the last slide. I put conclusions over to you, as I think this is an open question. Well, what are there any themes? It could be thought, well, this is an interesting diversion, but there is no sort of wider a theme here. Perhaps this is just two examples of really extreme examples of dishonest claimants who systematically deceived experts. Elliot, as you said, we've had 827 claims in a decade. So if 2 of them end up with committal hearings, that's obviously an extremely small proportion. It could be thought, though, is this a growth area? We've only had fundamental dishonesty for 9 years now since Quox came in. But Mr. Justice Ritchie's appendix does tell us about Calderdale and Atwell. Interestingly, Metcalf, the same trust, Calderdale, that was the first of its kind pursued by the NHS Trust after a dishonest clinical negligence claim. So since 2018, we have had 5 clinical negligence claims ending in committal proceedings in the last 4 years, including these two cases, both in the last 2 years. And again, as a question, I'm not sure what the answer is. Could Cauda Equina claims be, obviously the risk is absolutely still very low. This is a very small number of claims, but could they be relatively high risk for these factors, claimant dishonesty, surveillance evidence, and then ultimately contempt of court? And I pose the question there, well, we're dealing with very serious injuries in this case, these kind of cases by their nature, but they're not clear cut. They're not sort of Asia A paraplegia where there's no argument about whether someone has motor power or not. Could the combination of potentially very serious injuries and very large 7-figure schedules, could that be tempting a minority of claimants to behave like these 2 did? That's the open question, which I think I'll leave, Elliot, as it's I think now must be time for our next talk.
It is indeed, Tom. Thank you very much. That was a wonderful talk. I had flashbacks to all of my surveillance cases, including my favourite one of the wheelchair-bound client caught going for a jog. But anyway, I shall move on. Bittersweet.